or they're under duress about being extorted, for example, the payment of funds, we do respect people. Some people choose to buy very expensive vehicles, for example. Some people choose to purchase less expensive vehicles. So people make choices about what they're prepared to pay for a service.
Sure, although the vehicle analogy may not be the most apposite, given that, you know, there's a difference between a Yaris and a Roller in terms of size and quality and the like, I get, well, in terms of what you get for your money. But in terms of an organisation, you've talked about the issue of people handing over their money readily because they're happy to. To what extent would the ATO look at issues of duress, unconscionability in terms of the contract, in a sense, to hand those fees over if they're way beyond what is the norm for those sorts of services? To what extent do you take that into account?
Those matters tend to, I guess, drift towards questions of criminality.
Well, unconscionability is not a criminal matter, it's a civil matter.
Well, yes, perhaps contractual and not specifically a taxation question. So why would perhaps have regard to it? It wouldn't be a primary function of the tax office to be examining whether contracts between parties were necessarily unconscionable or perceived by others to be unconscionable.
But wouldn't that be relevant, though, in considering whether they ought to have that tax-free status?
It would be a relevant factor. However, the process by which someone might establish that any particular contract is unconscionable is not prima facie the function of the tax office in looking at the tax concessions granted to charities.
See, that alludes to matters that Senator Cameron raised with you. You're saying that the unconscionability of a transaction where money's handed over for services by a charity may, in circumstances, the unconscionability of that may be a factor in determining whether it has a tax-free status, but you're saying that the tax office doesn't have an ability to determine that because it goes outside its functions. Is that a fair summary?
Probably a fair summary of my inelegant explanation. Yes.
No, I'm not suggesting you being inelegant at all, but I'm just saying I think what is inelegant is the system, the way that so unconscionability could be a factor, but the ATO doesn't have an ability to determine unconscionability.
More clearly, perhaps, to explain would be, say, a matter of criminal behaviour by an organisation, and short of a taxation crime, the tax office would be up to, say, the police department, public prosecutions, for example, to determine if an organisation was criminal. If that was known to be shown and proven, then easily the tax office can respond to that circumstance. The tax office, though, wouldn't necessarily be undertaking, and nor is it a function or a role to undertake the pursuit of a criminal matter.
But I'm not talking about criminal matters, I'm talking about unconscionability, which is a defined civil law concept, and under the Trade Practices Act as well. If there was a court case against an organisation for an unconscionable conduct, would that, and there was a finding against that organisation, would that be a factor that you could then take into account if there was a court judgment?
Certainly, and as you said, for example, the Trade Practices Act, which is a piece of legislation administered by another organisation, they would have the primary carriage of that determination.
Sure. But you are hamstrung, and this is not a criticism of you or the ATO, but under the way the rules operate now, you are hamstrung to make those findings because you don't have the resources or the structure to do so.
It's more a matter of, I think, the order of events or the order of process, Senator, isn't it? A person can allege that another person has done something wrong, be it criminal or civil, and the ATO is probably not very well placed to determine whether that person's allegation is right or wrong. If that person goes off and pursues the ordinary remedies or pursues the avenues of complaint and redress that might be available to them, if it's criminal, to the police, if it's civil, to the relevant government sort of consumer protection organisations, or by going to law themselves and suing the person that they've made allegations about, and as a result of taking that action, the complainant is then able to go to the ATO and say, look, you know, my complaint has been upheld. So you, the ATO, don't have to make a judgment about the complaint that I'm making. Some other institution or process has already reached a finding on that particular element of it, and then it's up to the ATO, amongst other things, to determine whether the person who has done the wrong thing was acting as an individual, or whether that person was actually, if you like, part of a course of conduct that was condoned by the relevant entity. That's, if you like, I think where the ATO will most critically need to come to judgment, rather than taking the member of the public's initial allegation at face value and then pursuing that, because the ATO's role is not to pursue every complaint that any member of the public has about any other individual and whether or not that other individual has done them wrong.
But Mr. Wilcock, isn't the problem that the ATO, for instance, under ruling 2005-21, has to consider a number of factors in terms of the charitable status, the tax-free status of an organisation? There are a number of factors that it needs to tick off, so it needs to make a determination in respect of those. But insofar as if there is an allegation of a breach, it can't undertake the same exercise. There does seem to be a disconnect between the approval process and, if you like, the disapproval process.
Well,
and it's not a criticism, it just seems to be a disconnect.
I can understand your observation. The approval process, if you like, or the endorsement process, an organisation will approach us with, of course, their best presentation of all the things that they do which are perhaps charitable.
And you need to make an assessment of that.
We do. They are unlikely to say, oh, and we're also under investigation by trade practices, consumer protection. However, if that was known, and if that had been publicised as a court finding, that would be public information relevant to us.
But I guess the observation, and I won't take this any further because I want to move on. I've got a number of other questions to ask of both the Treasury and the ATO. But it seems that under the current rules, you need to make an assessment as to whether it gets approval, and you seem to have the capacity to do that, but you don't have the capacity to determine whether it ought to have its tax-free status removed for the reasons that both you and Mr. Wilcock have outlined. I won't take it any further, but that does seem to be a dilemma from my point of view. And it's not a criticism, it's just a dilemma.
I understand your dilemma.
Well, I think it's a dilemma for a much broader public dilemma. Under ruling 2005-21, in relation to paragraph 76, it refers to benefits for owners. An organisation, it states, an organisation is not charitable if it is carried out on for the purposes of profit or gain to particular persons, including its owners or members. This is known as a non-profit requirement. My question to you is, if an organisation was ensuring that the hierarchy of that organisation was going on overseas trips, or by itself not a bad thing, but if it seemed that a significant proportion of the revenue of that organisation, or there was significant enrichment for particular individuals, is that a factor? And also, insofar as we're dealing with Australian income and Australian revenue, or you know, assets, we're dealing with the Australian jurisdiction. If an organisation is sending money overseas to wherever that may be, the head office or the head church, to what extent should and does the ATO look into those factors?
Certainly the factors of private benefit or private enrichment or enrichment of the organisational leaders would be a concern. It would be inconsistent with charitable purpose, and it would be something which we could take into account as to whether an organisation would continue to have charitable status.
Well, where do you draw the line? I mean, do you say that a reasonable salary is the modest stipend of a union official, as Senator Cameron used to be, or that of the chief executive of a major bank?
Well, and that is a difficult, in practice, a very difficult judgment call to make.
But it's a call you have to make, isn't it?
We do.